Well, over the past few months, the debate on religious freedom has rarely left the headlines as Israel Folau's public fight with Rugby Australia has drawn out. But of course, this debate first had its origins in commitments made by Malcolm Turnbull around the time of the same-sex marriage plebiscite to protect religious freedoms. That was his promise. Now, he commissioned a report at the time chaired by Philip Ruddock and others, but the report sat on his desk and he left the parliament, leaving it as unfinished business. Well, it's now on Scott Morrison's desk, and the internal consultations have started about what changes might be put to the parliament by the government and what those changes might constitute, what they might mean for you, me and everyone else who's concerned about the issue of religious freedom. Do we want a minimalist sort of change here that's light on prescription? That would be the traditional approach of Conservatives, I have to say. Or do we want to see an expansive new law in Australia that protects religion, all religions, not just the ones we might profess ourselves? And if we did, what would that look like? Joining me tonight to walk through some of the complexity in this debate is the Executive Director at the Institute of Public Affairs, John Roskam, and Liberal MP for the federal Victorian seat of Menzies, Kevin Andrews. Gentlemen, thank you very much for your time. I want to start with you if I can, John. I was struck by some comments that you gave to the Australian newspaper today. I want to refer to them if I can. You said that a religious discrimination bill has the potential to make society less free. Tell me more.
That's right, Peter. We haven't seen the legislation as you've identified, but what we are hearing is that there's the risk that questions of religious freedom might be determined by the Human Rights Commission. And there's a third model, as you correctly identified. There's perhaps a minimalist model, a maximal model, or my view is less laws that restrict freedom of religion and freedom of speech. So you can absolutely understand what the government is trying to do. You are right that this should have been solved at the time of the same-sex marriage plebiscite or before, because this issue has been with us for a number of years. The government is trying to solve a wicked problem, but they need to be very careful about how this is done. And I'm also very concerned that this process has so far been conducted largely in secret. I'm the last one to call for a government committee or a government inquiry, but all of the public has to be involved in this, and we have to do this very carefully.
Yeah, I agree with you on the secrecy point. I mean, one of the difficulties has been that there was a report that went to the Prime Minister at the time, Malcolm Turnbull. It was unhelpfully leaked by somebody in the middle of the Wentworth by-election to the government's detriment. You can all work out who that might have been. But Kevin, I guess we're all talking around this issue of religious freedom without sort of knowing whether the government wants to deal with it as an exceptions bill in relation to discrimination, or they want to create and basically codify a lot of the freedoms that we have. Now, you're a Conservative, as am I. I'll be interested in your view on that. But before we get to sort of the immediate question, you chaired a subcommittee, a human rights subcommittee of the very large and important Joint Standing Committee on Foreign Affairs, and you held the inquiry into the status of religion and belief. It dealt with a lot of these issues, or it certainly looked at these issues. What was the view of your fellow MPs?
There were two fundamental results from the inquiry, and it's not finished, and hopefully it will continue in this current parliament. But the results were that, firstly, despite what people may generally believe in Australia, there is actually very little legal protection for freedom of religion and belief in this country in our domestic law. And secondly, without dissent, the committee said that we've signed up to an international standard, namely Article 18 of the Universal Declaration on Human Rights and Article 18 of the Political and Civil Covenant. Both of those are there as Australia's being signatories to them, but they're not in domestic law. And we should seek to put into domestic law the protection that's in both of those articles. Now, it's not the only protections missing in domestic law in Australia. We've got effectively discrimination law incorporated into domestic law, but freedom of association, freedom of speech, and in this case, freedom of religion and belief, although we've signed up to the international instruments, are not in domestic law.
Yeah, but just on that point, John Roskam, under the international covenants, there is a right to freedom of religion insofar as it doesn't rub up against questions of public morality or questions of what's allowed in the domestic law of the particular country. So, for example, whilst you can believe in Islam in Australia and you can believe in Islam as much as you can believe in Christianity or any other faith, of course, some of the tenets of these faiths in relation to, say, female genital mutilation or child marriage are not prohibited in Australia. So where do we get into risky territory legislating for freedom of religion and where it sort of bumps up against our domestic law or even the right of people under freedom of speech to criticise religion?
Peter, you put your finger on it, and this is exactly the challenge that Kevin raised. You can protect freedom of religion and freedom of speech by what's called a positive right. But for me, the concern is then that is interpreted by judges and courts and lawyers and the Human Rights Commission. Or you can protect freedom of speech and religion by not legislating against it. And part of the problem is that we have state and federal law that now makes it unlawful to offend someone, to be hurtful to someone. And what we have now is that when you are expressing a religious belief, you might hurt someone's feelings, you might be offensive to them. And this is the challenge. So creating a positive right means that courts will have to interpret whether it is a legitimate religious belief, whether it is not hurtful or not, whether it is not offensive or not, how far it goes, and exactly can, as a matter of your religious belief, you say you believe or encourage people to do things that are against Australian law. So these are exactly the issues the Parliament is going to be grappling with and the issues you've raised.
And also, Kevin Andrews, the question of what is religion, because I remember the debate about the Labor government setting up the Charities Commission, the not-for-profit Charities Commission, and what was constituting a charity went beyond what people thought it would be. It wasn't just the Salvos and St Vinny's and the charities that we know. It was a lot of environmental fronts. It was political fronts. It was, I have to say, a lot of sort of ratbaggery around the edges. Now, there were a range of sects, cults, organisations of dubious nature that might call themselves a religion. I mean, how do you even define what religion is?
Well, we've had High Court authority on what a religion is for some decades now. I don't think that's necessarily the most difficult point in this conversation. But to come back to John's point, if you look at Article 18 of the the Covenant on Political and Civil Rights, it does say that you should be free to manifest your religion or belief, provided it doesn't it's not contrary to a law, and it's not necessary to stop that in order to protect things like health or public morals or order or things like that. So there's already a schema, if you like, that we've agreed to. But the difficulty here is that in international jurisprudence, there's no hierarchy of rights. But in effect, in Australia, we have got a hierarchy because we have put into domestic law the provisions that relate to discriminating against someone, and we say that that's wrong and you can bring action. Yet somebody might be simply expressing their conscientious or religious belief, or indeed none, and that comes up against the discrimination provision. And at the moment, the discrimination provisions trump, as we saw in the case of Archbishop Porteous and other pastors in Tasmania, and other cases we've seen to date. So how we balance these things is the real issue.
Can I just jump in there, Kevin? So would the better way be to model this law where the others sit as sort of an exception to the rule, the anti-discrimination on race, the anti-discrimination on gender, do it in that sort of vein, what I'd call a minimalist model, yes, rather than create... Because otherwise, if you create a big, almost omnibus on freedom of religion as a positive right, you'll then have calls for gender to be a positive right or race to be a positive right. Is that the problem?
That's the problem. It's the clash of different values here, which is at the crux of the difficulty that we're trying to grapple with. It's the different rights that people have, the right to have a religious belief, to have a conscientious belief versus the right not to be discriminated against. Now, as I understand, I haven't seen the draft of the legislation and I'm yet to get a briefing from the Attorney-General, but as I understand the approach is more the minimalist approach.
How do you think they resolve all of this, John Roscombe, to protect what we have and not see a further erosion in our rights? Or I think also the risk of basically getting a backdoor Bill of Rights, which, you know, I don't know about you, but I've been violently opposed to for a long time.
As am I, Peter, and there's a couple of issues to what you raised. The first is even a minimalist model, and I can understand, as we've talked about, what the government is trying to do, risks having the Human Rights Commission define what religion is and what is appropriate. And exactly as you say, even if we define it by exception and we apply religion perhaps in the same way as sex discrimination has been applied, in relation to sex discrimination, you can still discriminate if it is regarded as reasonable. So in the Israel Folau type situation, you still might have an organisation saying that we have discriminated against someone on the basis of their religion because what they've said is hurtful or offensive, and the Human Rights Commission can still say, well, that's okay, you can discriminate because it is hurtful and offensive. My argument would be these sorts of big, important debates are best resolved by the community, by us agreeing to disagree and having the government remove laws that impinge on our freedom of speech and religion. The addition of extra laws has all of these problems, and the situation is not ideal at the moment. But if you take it to the Human Rights Commission, as is being suggested, you're giving power to the Human Rights Commission. You're also reversing the onus of proof. It's going to make it very hard for employers to prove they didn't discriminate against someone on the basis of religion if this is the way the government is going to go. You have to leave it to the community. It's not for lawyers and judges to decide this.
The difficulty, Peter, is that...
Just before we go to a break, Kevin, I want to ask you a related question here, just before we go. Israel Folau, there is a debate whether or not this was part of an employment contract. We'll leave that for the courts and others to decide. But do you think it's right, Kevin, and you were a barrister before you came into Parliament, that an employer can contract away your rights outside of work hours, and in this case, a right to religion totally different to his football career? Do you think that's right?
Well, if you look at the case in the UK recently, the judges there seem to suggest that there is a dividing line between the two. I think what we have to look at is some sort of common sense approach, and also from a starting point that if someone is going to, by contract, have their rights removed, that contract has to be very definite so that the person understands what it is. If it's just a general contract that says you can't bring the company or the sponsor or the sport into disrepute, for example, then I think that's not adequate to remove somebody's rights.
All right, gentlemen, thank you very much for your time. This issue obviously will not go away, and I'm sure I'll be speaking to you again in the not too distant future.
Thanks
for your time tonight.
Thanks, Peter. Thank you.